Question 1. A California Notary Public must record all of the following in their journal for an acknowledgment, except A. The character of every instrument. B. The fee charged, if any. C. The signature of the person whose signature is being notarized. D. The expiration date of the identification document presented. Answer: D. The expiration date of the identification document presented. For an acknowledgment, a California Notary Public's journal entry must include the character of the instrument, example deed, power of attorney, the fee charged, if any, and the signature of the person whose signature is being notarized. While the type of identification used must be recorded, the specific expiration date of the identification document is not a statutorily required element for journal entries in California. Always remember that your journal is the primary record of your official acts, so accuracy and completeness according to state law are paramount. Question 2. For an acknowledgment, a California Notary Public certifies that the signer A. Signed the document in the notary's presence. B. Appeared before the notary and affirmed the truthfulness of the document's contents. C. Appeared before the notary and acknowledged executing the document. D. Is authorized to sign on behalf of a corporation or entity. Answer: C. Appeared before the notary and acknowledged executing the document. An acknowledgment certifies that the signer personally appeared before the notary public and acknowledged that they signed the document. It does not require the document to be signed in the notary's presence, nor does it certify the truthfulness of the document's contents or the signer's authority to sign for an entity. The core concept of an acknowledgment is the signer's declaration that they are the person who signed the document, reinforcing its authenticity. Always confirm the signer's identity and their acknowledgement of signing the document to ensure a valid acknowledgement. Question 3. What is the maximum fee a California Notary Public may charge for taking a single signature acknowledgement? A. $10. B. $15. C. $20. D. $25. Answer: B. $15. As of January 1, 2017, the maximum fee a California Notary Public may charge for taking a single signature acknowledgement is $15. It's crucial for notaries to be aware of and adhere to the established fee schedule to avoid overcharging clients, which can lead to disciplinary action. Always keep an updated list of the state's maximum allowable fees handy to ensure compliance. Question 4. A notary public may certify a copy of a document if it is a California A. Birth certificate. B. Death certificate. C. Power of attorney. D. U.S. naturalization certificate. Answer: C. Power of attorney. In California, a notary public is generally prohibited from certifying copies of vital records like birth or death certificates, or public records if a certified copy can be obtained from the issuing agency. However, a notary public is specifically authorized to certify copies of a power of attorney, provided the original document is presented to the notary. This specific allowance helps individuals who need authenticated copies of this important legal instrument. Always remember that for all other documents, direct the requester to the proper custodian of the original record. Question 5. Which of the following is a mandatory requirement for a California Notary Public's official seal? A. It must be rectangular in shape. B. It must include the expiration date of the notary's commission. C. It must contain the Great Seal of the State of California. D. It must be photographically reproducible. Answer: D. It must be photographically reproducible. A California Notary Public's official seal must be photographically reproducible, meaning it can be clearly duplicated when scanned, photocopied, or faxed. While seals often include the commission expiration date, this is not a mandatory requirement for the seal itself, and the shape is not strictly limited to rectangular. The Great Seal of California is not required on a notary seal. Ensuring your seal meets all statutory requirements is crucial, as an improperly executed seal can invalidate a notarization. Always inspect your seal regularly to ensure it produces clear, legible impressions. Question 6. If a notary public's commission is suspended, the notary must A. Immediately return their journal and seal to the Secretary of State. B. Continue to perform notarizations only for family members. C. Notarize documents for no fee until the suspension is lifted. D. Destroy their seal and journal. Answer: A. Immediately return their journal and seal to the Secretary of State. If a notary public's commission is suspended, they must immediately cease performing all notarial acts and, within 30 days, surrender their official seal and notarial journal to the Secretary of State's office. Continuing to notarize under suspension or destroying the seal/journal would be illegal and subject to further penalties. This strict requirement ensures that official notarial tools are taken out of circulation when a notary is not authorized to act. Always prioritize compliance with official directives regarding your commission status to avoid serious legal consequences. Question 7. A California Notary Public is prohibited from performing a notarial act if they have a direct financial or beneficial interest in the transaction. Which of the following scenarios describes such a disqualifying interest? A. The notary is notarizing a document for their neighbor. B. The notary is named as a grantor in the real property document being notarized. C. The notary is an employee of the company for which the document is being notarized. D. The notary will receive a standard notarial fee for the service. Answer: B. The notary is named as a grantor in the real property document being notarized. A notary public has a disqualifying financial or beneficial interest if they are a party to the instrument or have a direct financial or beneficial interest in the transaction, which includes being a grantor in a document. Notarizing for a neighbor or being an employee of a company involved in the document does not automatically create a disqualifying interest, nor does receiving the standard notarial fee. This rule prevents potential conflicts of interest and maintains the impartiality that is fundamental to the notary's role. Always step aside if your personal involvement in a document or transaction creates even the appearance of a conflict of interest. Question 8. A California Notary Public must notify the Secretary of State of a change of business or residential address within A. 10 days. B. 15 days. C. 30 days. D. 60 days. Answer: C. 30 days. A California Notary Public is required by law to notify the Secretary of State of any change in their business or residential address within 30 days of the change. This notification ensures that the Secretary of State can maintain accurate records for all commissioned notaries and reach them if necessary. Failing to provide timely notice can result in fines or other disciplinary action. Always update your address with the Secretary of State promptly to remain in compliance with your commission requirements. Question 9. Before performing a jurat, the California Notary Public must administer an oath or affirmation to the signer. What does this oath or affirmation relate to? A. The signer's identity. B. The date the document was signed. C. The truthfulness of the document's contents. D. The signer's understanding of the document. Answer: C. The truthfulness of the document's contents. For a jurat, the notary public must administer an oath or affirmation where the signer swears or affirms that the statements in the document are true. This core requirement distinguishes a jurat from an acknowledgment and is vital for ensuring the integrity of sworn statements. The notary is not certifying the signer's identity through the oath, nor the signing date or understanding of the document, but specifically the truthfulness of the content as declared by the signer under penalty of perjury. Always remember to administer a clear and formal oath or affirmation before having the signer sign the document in your presence. Question 10. Which of the following statements is true regarding a California Notary Public's advertising? A. They may advertise as notario publico if they also provide immigration consulting services. B. They must include a notice in their advertisement if they are not an attorney and cannot provide legal advice. C. They are exempt from advertising regulations if they only notarize for a single employer. D. They may use foreign language titles without restriction. Answer: B. They must include a notice in their advertisement if they are not an attorney and cannot provide legal advice. California law strictly regulates notary advertising, especially concerning the use of foreign language titles. A California Notary Public who advertises in a language other than English must include a specific, prominent disclaimer stating that they are not an attorney and cannot give legal advice. The term notario publico is prohibited as it can mislead foreign language speakers into believing the notary has legal qualifications similar to a lawyer in some Latin American countries. This rule protects the public from potential fraud and misunderstanding. Always ensure your advertising clearly communicates your scope of services and limitations to avoid misleading consumers. Question 11. When performing a notarization for a person who signs with an X signature by mark, what must the California Notary Public require? A. 2 subscribing witnesses only. B. 1 credible witness to attest to the mark. C. The signer to present a valid identification document. D. 2 disinterested persons to witness the execution of the document by mark and sign their own names. Answer: D. 2 disinterested persons to witness the execution of the document by mark and sign their own names. When a person signs a document by mark X, a California Notary Public must require 2 disinterested persons to witness the execution of the document by the mark and sign their own names to the document. These witnesses attest that the mark was indeed made by the individual. The notary must also obtain satisfactory evidence of the identity of the person making the mark. This procedure adds an extra layer of verification for documents signed by mark, enhancing their reliability. Always ensure these 2 witnesses are truly disinterested and sign the document themselves, in addition to the person making the mark. Question 12. A California Notary Public is required to obtain a surety bond in the amount of A. $10,000. B. $15,000. C. $20,000. D. $25,000. Answer: B. $15,000. A California Notary Public is required to obtain a $15,000 surety bond, which is designed to protect the public from damages caused by official misconduct or negligence by the notary. The bond is not an insurance policy for the notary but rather a financial guarantee to cover potential claims against the notary's official acts. Understanding the purpose of the bond helps notaries recognize their responsibility to act lawfully and ethically. Always remember that your bond is a safeguard for the public, not a substitute for carrying out your duties correctly. Question 13. Which of the following acts is always prohibited for a California Notary Public? A. Notarizing a document for a family member. B. Notarizing a document in which the notary is named as a party. C. Notarizing a document for an out-of-state resident. D. Notarizing a document outside of their county of residence. Answer: B. Notarizing a document in which the notary is named as a party. A California Notary Public is absolutely prohibited from performing any notarial act where they are named as a party to the instrument, or have a direct financial or beneficial interest in the transaction. Notarizing for family members is generally permissible as long as the notary is not also a named party or beneficiary. Notaries can notarize for out-of-state residents and operate anywhere within California, regardless of their county of residence. This prohibition reinforces the requirement for notary impartiality and prevents conflicts of interest. Always refuse to notarize if your personal involvement could compromise your neutrality. Question 14. What is the primary purpose of a California Notary Public's journal? A. To serve as an official record of all notarial acts performed. B. To track the notary's income for tax purposes. C. To verify the authenticity of documents notarized. D. To serve as an appointment book for notary services. Answer: A. To serve as an official record of all notarial acts performed. The primary purpose of a California Notary Public's journal is to create a detailed, chronological official record of every notarial act performed. This journal is a critical tool for accountability and for protecting both the public and the notary. While it can indirectly help with income tracking, its main role is to document compliance with notarial laws, not to verify document authenticity or manage appointments. Maintaining a complete and accurate journal for every notarization is paramount and a statutory requirement. Question 15. A California Notary Public may refuse to perform a notarial act if A. The signer speaks a language the notary does not understand. B. The notary believes the signer is not appearing willingly or is being coerced. C. The document contains content that the notary personally disagrees with. D. The signer requests the notary to backdate the certificate. Answer: B. The notary believes the signer is not appearing willingly or is being coerced. A California Notary Public is obligated to refuse a notarial act if they have reasonable grounds to believe that the signer is not appearing willingly, is being coerced, or is mentally incapable of understanding the transaction. The notary's role is to ensure voluntary consent and comprehension. While a notary must refuse to backdate a certificate, which is illegal, the prompt asks when a notary may refuse, allowing for discretionary situations. Disagreement with content is not a valid reason, and while understanding the signer is important, it doesn't automatically mean refusal unless identity or understanding is compromised. Always trust your judgment when assessing a signer's willingness and awareness. Question 16. If a California Notary Public resigns their commission, they must deliver all their notarial records and materials to the county clerk's office in the county where their principal place of business is located, within A. 10 days. B. 30 days. C. 60 days. D. 90 days. Answer: B. 30 days. Upon resignation of their commission, a California Notary Public must transmit all notarial journals, records, and the official seal to the county clerk's office in the county where their principal place of business is located, within 30 days. This requirement ensures the proper archiving of official records, which remain public property, for legal and investigative purposes. Proper and timely surrender of these materials is crucial for compliance and to avoid penalties. Always remember your official records are not your personal property, they must be properly transferred upon the end of your commission. Question 17. Which of the following is an acceptable form of identification for a California Notary Public to rely upon for a notarial act? A. A birth certificate. B. A foreign passport stamped by U.S. Citizenship and Immigration Services. C. An expired driver's license from another U.S. state. D. A credit card. Answer: B. A foreign passport stamped by U.S. Citizenship and Immigration Services. A foreign passport that has been stamped by the U.S. Citizenship and Immigration Services, USCIS, is an acceptable form of identification in California, provided it is current or issued within the last 5 years. Birth certificates and credit cards are never acceptable forms of identification for notarization. An expired driver's license from another U.S. state is also generally not acceptable unless it meets specific, current criteria for expiration and recency, which is not the case for most notary acts. Always refer to the most current list of acceptable identification documents in the California Notary Public Handbook to ensure proper verification. Question 18. What is the maximum jail sentence for a notary public who willfully fails to perform any duty required of a notary public by law? A. 6 months. B. 1 year. C. 2 years. D. 3 years. Answer: A. 6 months. A notary public who willfully fails to perform any duty required of a notary public by law is guilty of a misdemeanor, punishable by a fine not exceeding $1,500 or imprisonment in the county jail not exceeding 6 months, or both. This penalty highlights the seriousness of a notary's responsibilities and the legal consequences of failing to adhere to statutory duties. Upholding your duties meticulously is not just good practice, it's a legal obligation. Question 19. If a document presented for notarization is incomplete, the California Notary Public should A. Fill in the missing information if it seems obvious. B. Refuse to notarize the document. C. Advise the signer to complete it in their presence before notarization. D. Notarize it and make a note in the journal that it was incomplete. Answer: B. Refuse to notarize the document. A California Notary Public must refuse to notarize a document that is incomplete. Notaries are prohibited from notarizing blank or incomplete documents because doing so could facilitate fraud or unauthorized alterations after the notarization. It is not the notary's role to complete missing information or to notarize documents with missing critical content. Always insist that the document be complete before you perform any notarial act to protect yourself and the public. Question 20. A California Notary Public is commissioned for a term of A. 2 years. B. 3 years. C. 4 years. D. 5 years. Answer: C. 4 years. A California Notary Public is commissioned for a term of 4 years. Understanding the duration of your commission is important for planning your reappointment and ensuring continuous service. Always keep track of your commission's expiration date to allow ample time for renewal, as the application process can take several weeks. Question 21. Which of the following information must always be included in the venue section of a California notarial certificate? A. The county and state where the notarial act was performed. B. The county of the notary's commission and the state. C. The city and state where the notarial act was performed. D. The notary's business address. Answer: A. The county and state where the notarial act was performed. The venue section of a California notarial certificate must always state the county and state where the notarial act actually occurred. This ensures that the location of the notarization is clearly documented, which is crucial for legal validity. The notary's commission county or business address is irrelevant for the venue, and simply the city is not sufficient. Always accurately record the exact county and state where you are physically present when performing the notarization. Question 22. When a California Notary Public performs a jurat, they must ensure the signer A. Signs the document in the notary's presence. B. Signs the document prior to presenting it to the notary. C. Provides 2 credible witnesses. D. Is personally known to the notary. Answer: A. Signs the document in the notary's presence. For a jurat, the California Notary Public must administer the oath or affirmation, and then the signer must sign the document in the notary's presence. This sequence is critical because the act certifies that the signer swore to the truthfulness of the document's contents before signing it in front of the notary. This direct observation of the signing solidifies the integrity of the sworn statement. Always make sure the oath is administered, and the signing takes place right in front of you. Question 23. If a California Notary Public changes their name, they must notify the Secretary of State within A. 10 days. B. 15 days. C. 30 days. D. 60 days. Answer: C. 30 days. If a California Notary Public changes their name, they must notify the Secretary of State within 30 days of the effective date of the name change. This ensures that the Secretary of State's records accurately reflect the notary's identity. Upon notification, the notary typically receives an amended commission certificate and must obtain a new seal reflecting the new name. Always prioritize updating your commission details, as an outdated name can lead to issues with your official acts. Question 24. A California Notary Public must maintain their journal. A. Until their commission expires. B. For a period of 5 years after the last entry. C. For as long as they are a commissioned notary. D. For the entire duration of their commission plus 7 years. Answer: C. For as long as they are a commissioned notary. A California Notary Public must maintain their journal for as long as they are a commissioned notary, and upon resignation, expiration, or removal from office, the journal must be delivered to the county clerk's office. This continuous maintenance ensures a complete record of all notarial acts throughout the notary's career. Your journal is a perpetual record, not just for the term of a single commission. Question 25. Which of the following is considered a primary acceptable form of identification for a California Notary Public? A. An inmate identification card issued by the California Department of Corrections and Rehabilitation, if the inmate is in custody. B. A foreign driver's license from Canada. C. A U.S. Department of Veterans Affairs identification card. D. A U.S. alien registration card, green card. Answer: A. An inmate identification card issued by the California Department of Corrections and Rehabilitation, if the inmate is in custody. An inmate identification card issued by the California Department of Corrections and Rehabilitation is an acceptable form of identification for notarizing documents for an inmate who is in custody. While foreign driver's licenses and U.S. Department of Veterans Affairs cards generally require additional verification or are not acceptable on their own, and if green card is acceptable, the inmate ID is specifically listed for incarcerated individuals. It's crucial to know the specific types of ID acceptable under California law, especially for unique situations like notarizing in a correctional facility. Always confirm the exact requirements for each type of identification presented.